Welcome back. It's now 1:35 and this is the Licensing Subcommittee for Zaytuna. So, in the matter of the Licensing Act 2003, application for variation of premises licence Zaytuna Moroccan, 17 Marmion Road, Southsea, all parties shall receive written confirmation of the decision and reasons. The subcommittee has considered very carefully the application for variation of a premises licence at Zaytuna. It gave due regard to the Licensing Act of 2003, the licensing objectives, statutory guidance and the adopted statement of licensing policy. The subcommittee considered the relevant representations, both written and given at the hearing by all parties. Human rights legislation and the public sector equality duty has been borne in mind whilst making the decision. The subcommittee noted that the application sought an extension in hours of the sale and supply of alcohol, the provision of late night refreshment and an extension of opening hours at the premises. An extension was sought for live and recorded music and performance of dance on New Year's Eve. There had been representations from two residents. Those objecting raised concerns broadly in relation to the licensing objectives of public nuisance and crime and disorder. The issues of concern relating to noise are particularly from customers and staff at the rear of the premises dealing with waste as well as arising from karaoke nights, etc. Concerns were expressed about the provision of bottomless brunches in the past, which led to antisocial behaviour during the daytime. No formal representation had been made by responsible authorities. In particular, it was noted that neither the police nor environmental health had raised any concerns with the application. It was noted that the applicant had amended the application as set out in their letter produced at page 115 onwards of the report, noting the differences between the premises and allowing for a phased closure. After having heard all of the above evidence, the subcommittee determined, to grant the proposed application in the amended terms sought. The subcommittee listened very carefully to residents' concerns and has had to balance those against the interests of the business. In doing so, it's had to determine the extent of the impact that the proposed variation might have upon the licensing objectives of the prevention of public nuisance and crime and disorder. The subcommittee has had to take account of the fact that no representation had been received from the police nor environmental health at this stage, and therefore the inference being that their expert professional position is that the proposal is not considered likely to undermine the licensing objectives. Weight has been attached to the position as each are considered the lead in their respective field. Residents indicated that the premises is located in a residential area and is part of a block of flats. However, the subcommittee has had to consider whether the proposed variation is likely to undermine the licensing objectives. The residents have a sincere fear that additional hours will be inevitably lead to issues previously experienced, particularly with bottomless brunches. For the premises, the subcommittee heard that the premises is now to be run under the direct control of the applicant, it being accepted that the previous management had caused issues and lessons have been learned. The repeated assertion being that the premises shall be run as a restaurant with background music only, there'll be no bottomless brunches offered or unlimited alcohol promotions, and there'll be no karaoke. It was noted that the application didn't seek to amend the hours of live entertainment or recorded music at the premises, apart from New Year's Eve. The subcommittee was also reassured by the processes to be implemented to secure training of staff and that the closing of the premises is smoothly managed. The subcommittee will expect that the opening of doors to the rear of the property and playing music of staff after hours will be supervised and properly managed to prevent noise escape of the premises. The subcommittee acknowledges that concerns of residents objecting to the proposed hours is disappointed to hear that the premises had difficult history with the same premises licence in the holder, albeit under a different management. The subcommittee recommends that the premises and residents engage in a dialogue to address concerns in future and is reassured to see the applicant has provided his personal contact number moving forward. In the event that the proposed operation of the premises does lead to issues of concern, residents are strongly advised to report matters to environmental health or the police where appropriate. Residents can very much be reassured that there are powers to deal with the premises if a licence leads to the licensing objectives being undermined. Not least is the power for residents or responsible authorities to bring review proceedings where steps can be taken to restrict the licence, impose conditions, or in extreme circumstances revoke the licence when evidence shows issues result from licensable activity. Action can also be taken separately by environmental health in relation to statutory nuisance if reported. The subcommittee heard legal advice during the hearing and that confirmed that the amended operating schedule, particularly as set out in the mentioned letter, would be converted into conditions attached to the licence. On balance, and in light of the assurances given and protections given in place, the subcommittee was not satisfied that it would be appropriate to restrict the premises proposed application at this point in time. There is a right of appeal for all parties in the Magistrate Court, and formal notification of this decision will be set out in full. And I end the committee there.